Welcome to the Deep Dive. You're listening because you want to get right to the heart of important topics quickly and thoroughly. Today, we're tackling something pretty fundamental about our legal system. Yeah, we're looking at the length of United States Supreme Court opinions. Are they getting longer? And, what does that really tell us? We've got quite a bit of research here looking at majority, concurring, and dissenting opinions over time. And just to set the stage, consider this. The average majority opinion is already around 4,751 words. That's substantial.
It really is. It suggests these aren't simple pronouncements.
Definitely not. So let's dive in. What's the main story with majority opinions? Are they, in fact, getting bigger?
The evidence points strongly in that direction, yes. There's been a really noticeable increase over time. Take a recent, very high-profile example, Dobbs v. Jackson Women's Health Organization back in 2022.
Right, I remember that one.
That majority opinion clocked in at 35,631 words.
Wow.
Which makes it the third longest since the 1946-47 term. It really suggests a pattern for these major contentious cases.
That length is staggering for a single opinion. But is it just these landmark cases, or is the trend broader? Are the averages climbing?
They are. There's analysis looking at signed majority opinions from 51 up to the end of the 2013 term. And it shows a pretty clear upward trend in average length. In one recent term within that period, the average was 4,876 words.
Okay, so it's not just outliers like Dobbs.
Yeah.
The average itself is creeping up.
Exactly. It looks like a consistent pattern of growth over decades.
So that raises the question, what about way back, the early court? Were opinions always this, verbose?
Oh, not at all. Research going back to the very beginning, 1791 up to 2005, it shows the median length increased more than 5 times.
5 times?
Yeah. In the early days, the median was maybe 763 words. Compare that to 1986 through 2005, where it jumped to 4,250 words.
That's 763 words. That's barely a long email today. It's hard to even picture.
It's a completely different scale. It really shows how the court's communication has evolved dramatically.
So was it just a straight line upwards, or did it kind of ebb and flow?
Well, there were some interesting periods. The data shows a noticeable dip, actually, in the median length between about 1948 and 51.
Huh. Any idea why?
It's hard to say definitively from just the numbers, but then things really picked up again. There was a substantial increase after the Burger Court started around 1969.
Okay.
So these fluctuations, they hint that maybe changes in who is on the court or their approach or even the kinds of cases they took on probably influenced how long the opinions were.
That makes sense. It's not just about word count. It reflects bigger shifts.
Yeah.
Okay, so that's majority opinions. What about concurrences? When justices agree with the result but want to write separately.
Right. And what's really fascinating there is this growing tendency, Justice Kagan actually pointed this out, for justices to write their own thing, even if they're technically on board with the majority or the dissent.
So more individual voices.
Seems like it. Look at the recent Rahimi case. You had 8 justices in the majority, which is pretty unified on the outcome, but 5 of those 8 wrote separate concurrences. And get this, those concurrences together added up to 49 pages, the actual majority opinion, only 18 pages.
Wow. So the side notes were longer than the main text.
Significantly longer. It makes you wonder, if agreeing on what to decide is becoming separate from agreeing on why.
That definitely suggests a court where maybe the individual reasoning is getting more emphasis. Is there data showing more concurrences overall?
Oh, absolutely. The numbers are pretty stark. If you look at the average number of concurring votes per majority opinion, it went from about 0.30 back in the 1955-56 term to 1.44 in the 2023-24 term.
That's also a 5-fold increase.
Exactly, a nearly 5-fold jump. It seems more justices feel the need to lay down their specific marker.
And like you said with Rahimi, these aren't just quick, I agree, but notes, are they?
No, not always. There was another case where Justice Kavanaugh wrote a 24-page concurrence. The majority opinion in that case was only 18 pages.
So the concurrence was longer than the majority again.
Right. It underscores that these can be really substantial legal arguments in their own right.
So more concurrences, sometimes quite long ones. What's the implication? How does that change things?
Well, if you connect the dots, it suggests maybe a less unified court, at least in its reasoning, even when they agree on who wins or loses. And that fragmentation, it could make it harder for lower courts, or anyone really, to figure out the exact legal rule the court is laying down. It might also signal, individual justices trying to steer the law in their preferred direction over the long term.
Interesting, like a public dialogue happening within the opinions themselves.
Okay, let's switch gears to the other side.
Yeah.
Dissents. When justices disagree outright, are they getting longer too?
Yes, that trend seems to hold for dissents as well. We mentioned the Dobbs case earlier. Well, the joint dissent in Dobbs spans 66 pages.
66 pages just for the dissent.
Yeah, a very detailed rebuttal. It really highlights the intensity and, frankly, the complexity of what the court was grappling with.
And is dissent itself just more common now? Well, one study looked at the terms in 1963, 1980, and 1990. It found dissenting opinions in 62% of the cases.
Wow, over half. So dissent is pretty standard fare.
It seems to be a significant part of the court's work, and there's this interesting idea that maybe a strong dissent pushes the majority to write more.
Ah, like they have to anticipate and counter the dissenting arguments.
Precisely. They might feel the need to provide a more thorough justification, a more robust defense of their own reasoning, because they know this critique is coming out alongside it.
Almost like a written debate. But dissents weren't always a thing, right? Didn't the early court do things differently?
That's absolutely right. Early on, they used what's called seriatim opinions. Basically, each justice wrote their own separate opinion on the case.
So everyone just gave their own take.
Pretty much. There wasn't really a formal dissent as we think of it. The first one we'd recognize as such is generally credited to Justice William Johnson in 1805. And then, by around 1812, concurring and dissenting opinions became more regular. Even Chief Justice Marshall, who famously preferred the court to speak with one voice, eventually started dissenting himself sometimes.
So it took a while for the idea of openly disagreeing within the official opinions to take hold.
Right. It reflects a kind of evolution and acceptance that disagreement is part of the process.
So bringing it back to length, what does more recent data show for dissents?
Looking at the 2016 term, for example, the average length of a dissenting opinion was about 12.8 pages.
Okay, still substantial.
Definitely. And that long-term data, the 1791 to 2005 series we mentioned earlier, it confirms that both concurring and dissenting opinions have become more frequent over time. It points to a court that's just less unanimous than it used to be.
Okay, so the picture is pretty clear. Majority, concurring, dissenting opinions, they all seem to be trending longer. Now the big question, why? What's driving this?
It seems to be a mix of factors, probably all interconnected. One big one people point to is ideological polarization.
How does that make opinions longer?
Well, if the court is more divided, majorities might be smaller, maybe 5-4 splits. When that happens, the justices in the majority might feel they need to write a really extensive opinion to justify their stance, maybe to shore up that narrow agreement, and also to directly refute the points the dissenters are making.
Right. A narrower win needs a stronger defense. Makes sense. What else?
Another factor is likely the kinds of cases the court is taking on. They seem more willing now to tackle really significant, sometimes politically explosive issues.
Like the Dobbs case again.
Exactly. Those cases often involve complex legal histories, deep societal disagreements, maybe overturning precedent. All that just requires more explanation, more justification, so the opinions naturally get longer.
Okay, polarization, bigger issues. What about changes inside the court itself? Like how it operates?
Yeah, that seems relevant too. The court actually hears far fewer cases now than it did, say, in the mid-20th century.
Fewer cases? You'd think that might mean shorter opinions?
Or it could mean they have more time to spend on each case they do hear. Plus, each justice now has more law clerks than they used to.
More staff support.
Right. So fewer cases plus more clerks could equal more time and resources devoted to drafting really detailed, comprehensive opinions. Some argue the clerks' own writing styles might even contribute to length.
That's an interesting angle. And what about just the tools? Has technology made it easier to write long?
Almost certainly. Think about writing with typewriters versus word processors.
Oh, yeah, big difference.
Electronic writing and editing tools make it so much easier to revise, expand, insert arguments, move things around. The physical friction of producing a long document is just much lower now.
So technology removes a barrier to length. Any other factors related to the cases themselves?
Well, just the inherent nature of some legal questions. Landmark cases, fundamental constitutional issues, cases overturning precedent. They almost by definition require digging deep into history, analyzing lots of prior cases, addressing counter-arguments. That just takes space.
And what about the justices themselves? Like strategically trying to keep their majority together?
Yes, that's thought to play a role too. The justice writing for the majority might need to add certain points or phrase things a specific way to keep other justices in the coalition happy. that can add length and complexity.
Sort of negotiating the text.
In a way, and as we said, a strong dissent often forces the majority to respond in kind, adding more detail to their own argument.
It really sounds like a complex web of influences. You also mentioned individual justices' confidence. How does that fit?
Well, one theory is that if justices feel particularly confident in their own legal interpretations or policy views, they might be more inclined to write separately, especially concurrences, to really articulate their specific reasoning, even if they agree with the outcome.
To put their own stamp on it.
Exactly. And that desire to shape the law from their perspective adds to the total number and length of opinions for a given case.
So pulling back a bit, these landmark cases seem to really exemplify this trend towards greater length. Can you remind us of some key examples?
Yeah, they really stand out. Dobbs, as we've mentioned, resulted in over 200 pages of opinions, total majority, concurrences, dissent. The majority itself was incredibly long, reflecting the gravity of overturning Roe v. Wade.
Right. A decision that big needs a massive explanation.
Right.
Were other abortion cases also lengthy?
They were. Roe v. Wade itself back in '73 and Planned Parenthood v. Casey in '92 were also known for being quite long. It seems inherent to the contentiousness and the need to navigate complex legal territory, maybe try to build and hold a majority.
And it's not just abortion, right? Other major constitutional fights.
Absolutely. Cases dealing with fundamental issues like, say, the Establishment Clause in religion, or incredibly complex regulatory schemes like campaign finance and McConnell v. FEC, or even older cases dealing with national security and rights like Communist Party v. Subversive Activities Control Board. Some of those topped 40,000 words.
40,000, that's practically a book.
It is. And in those cases, you often see very strong dissents, too, laying out completely different ways of looking at the law, maybe hoping to influence future courts.
It really drives home the complexity of what the court is asked to decide. Okay, so bringing this all together, as we wrap up this deep dive, what's the main takeaway on Supreme Court opinion length?
I think the core finding is pretty clear. There's a definite general trend towards increasing length across the board, majority, concurring and dissenting opinions. And it's not one single thing causing it. It seems to be a convergence of factors.
Right.
Things like ideological divisions, the court tackling bigger, more complex cases, changes in how the court works, fewer cases, more clerks, plus the ease of writing with modern technology.
What are the potential consequences of this? Longer, maybe more fragmented opinions. What does that mean for the law, for us?
Well, there are a few potential implications to consider. For lawyers, for lower court judges who have to apply these rulings, even for the public trying to understand the law. Longer, more complex, sometimes more fractured opinions can make it harder to figure out what the core holding actually is.
It can be harder to find the main point.
Exactly. Some experts worry that excessive length can actually obscure the key legal principles, making the law harder to apply efficiently and consistently. There's also a potential impact on how the court is perceived. If opinions become overwhelmingly long and full of separate writings, does that make the court seem less cohesive, less authoritative? It could affect public confidence.
So it's a balancing act. You need thoroughness, but you also need clarity.
Precisely. Comprehensive analysis is obviously crucial for the kinds of issues the Supreme Court deals with, but clarity and maybe some conciseness are also really important for the law to be accessible and seen as legitimate.
This has been really illuminating. It's an aspect of the court we don't often think about, but it clearly says a lot. Thanks for digging into this with us.
My pleasure. It's definitely a complex topic with lots of layers. Hopefully this gave a good overview.
Absolutely. And thanks to you, our listener, for joining us on this deep dive into Supreme Court opinion length.
Definitely something to chew on.
For sure. And maybe here's a final thought to leave you with. In our information-heavy world, how does this trend of longer, more complex Supreme Court opinions affect the public's grasp of the law and the judiciary's role? Is more detail always better, or can it sometimes get in the way of understanding?
That's a great question.
Maybe explore one of those landmark cases yourself, or read some opinions from different eras. See the difference firsthand. Until our next deep dive,